ಇದೆ ಏನು ಮಾಡಿದ್ದಾರೆ
Noted.
Fixing the 14%. I'm posting at 2:30 p.m. today. Here
Okay,
is a
no,
free
yes.
offer.
What happened to Mark was not coming in?
It has not come in the list today. Even though it was directed to be posted today,
They are not informed.
at least 2:30 p.m. it can be taken up. I am filing a memo.
Who is the advocate who has taken notice?
Mutana, Council Mutana have served the copy on them.
Tell Mr. Muttana, inform him and call. We'll take up this matter at 1 o'clock.
1 o'clock. Okay.
Inform Muttana
Good,
to get
good.
instructions. Yes,
My lord, sir, respondent bank has taken a coercive action by seizing the secured assets, my lord.
I'm not able to hear. Please use the mic.
Respondent bank has been taken a coercive action by seizing a secured asset, my lords. On the direction of the DRT, we have paid us a substantial amount. All that they are not,
Petition file.
my lords.
Which year is the writ petition?
My lords, 26, my lords.
It will come.
My lords, can you take it?
Don't make any fresh matters, no mentions are required.
My lord, DRT.
Of the list. Take it all the old matters, give the memos to the court officer as per the convenience of the court. Matters will be taken up. No. Yes. Yes. Call for those appeals. 1 o'clock. Yes. Huh? Yes. Why so early review? It will come. It will come in the first week. It will come on 6th. Yes.
My lord, DRT matter, my lord, WP, we have filed early hearing IA challenging the dismissal of SA order. Kindly date may be allotted, my lord. 23 matter.
Give it to the court officer. It will be allotted. All pending matters give to the court officer.
5 connected writ petitions, my lord. This court had directed the DRT to decide the OA, my lord. The DRT has decided the OA. Interim orders are there in this writ petition, my lord. 5 writ petitions. Now they have become infructuous, my lord. So the lords will take it up, my lord. Because 500 crores is the OA amount which has been allowed, my lord.
First.
IBC and
Business
surface
matters
matters
are
were
first.
challenged by the borrower.
This is a DRT matter challenging the eviction notice. My lords have filed it yesterday. There's some urgency because my lords, in the morning the bank officials have come near the scheduled property to take possession.
What they're going to do?
To take possession of the scheduled property.
No, what is questioned before this court?
Eviction notice, my lords.
13-4.
Please, my lords.
We'll see. Nothing will happen. We'll see.
If they are evicted from the property, it's a residential house.
So any of court will not interfere. Even if you know, if you're, if I grant you a matter at 1 o'clock, if I take up also, I'll not grant any order for you.
In fact,
Because you can't come before this court.
The
You have
bank
to go before the DRT.
What happened, Melas? The bank demanded 10 lakhs. Yesterday, we made a payment of
So
6
it is
lakhs.
not demanded. What you are supposed to
I
pay,
mean, I
you have to
understand,
pay.
Melas. To clear the overdue, 6 lakh we made a payment, 4 lakhs we could not arrange. But today we'll
What
be.
is outstanding?
Outstanding amount, to regularize the amount, my lords, it was 10 lakhs. To the complete outstanding was 56 lakhs.
If you're ready to pay, then only I'll take up the matter. Otherwise, it's just waste of court's time.
To clear the overdues, my lords, 10 lakhs, what the bank told, my lords,
No,
6 lakh payment
to
was.
regularize the account, the bank has to take a call. We can't tell them to regularize your account.
No, but as per their instruction, today we'll make 4 lakh, it will be regularized. But however, my lords, they are near the
Which
schedule.
bank is that?
IDBI Bank, my lords.
Any counsel is there? Because I'll not be granting any ex parte interim order without hearing the bank.
I have to-
Understanding, if any counsel is there, then any panel counsel for IDBA?
I'll serve a copy on them, my lords.
You're not only serving copy, you should get instructions, otherwise no interim order.
Please, my lords, I'll request the council, I'll serve a copy on them.
If anybody is there, then only I'll take up. I'm making it very clear. Otherwise, I'll not take up the matter.
Please, my lords, please.
Yes, 1 o'clock.
Mallards, it is the DRT, fresh matter, Mallards. There's a concept, the urgency, Mallards. The second respondent bank has already issued the auction notice, Mallards, and the e-auction is set to be connected by this week, Mallards.
Let it be.
Mallards, we're all ready, Mallards, to pay the amount, Mallards. All we're asking is a month's time, Mallards. Your Lordship, can you take up this matter
Come
by
on
end of this,
first, we
Mallards?
will see on first,
Please, please, Mallards.
provided office objections are complied with,
Please,
or else don't list the matter.
please.
Just call the list.
Lordship, fresh matter, Lordship, DRT matter, Lordship. Sale notice is issued on 9/3/26.
No, you know the SOP, 24 hours
Monday.
matters are being listed.
Monday is the sale,
Auction, let it go on. We can set it, we can again,
whatever amount is there, Lordship, 86 lakh rupees, 20 lakh.
that I'll
rupees
decide on
already paid.
first, not today.
Lordship, within.
List the matter.
Within
If it
6
is
months.
office objections are complied with on first. Yes. Yes, yes.
List number 1, page number 1, serial number 1, page number 2, serial number 2, page number 3, serial number 3 to 8, page number 4, serial number 9 to 10, page number 5, serial number 11 to 13, page number 6, 14 to 17, page number 7, 18 to 20, page number 8, 21 to
Serial
20.
number 24, ma'am. First attachment, other side inform, next week,
You want adjournment in a 24 matter?
please, next week, any date.
Is this matter in the month of June at the request of non-council petitioner?
That's
Yeah.
one.
At the request of
Climate.
non-council respondent. Yes.
Serial number, page number 9, serial number 25 to 28,
Yes. Huh? This also after, in the month of June,
serial number,
at the request of non-council petitioner.
serial
Yes,
number
sir.
10, serial number 29 to 14,
Serial number 34, my lord. Kindly week's time may begin. Serial number 34.
This also.
Serial number 29. Serial number 29 could be taken up.
No, no, 34 he is asking for adjournment. You are for the respondent. In 34. This also in the month of June.
29.
Yes, 29, what do you want?
Week's time can be granted for translation.
List this matter on 23rd of April.
List number 2, serial number, page number 1.
All
serial
these
number-
matters in list number 2, give the dates as per the convenience of the advocates. If any interim order is there, extend.
List number 1, for hearing on interlocutor application, serial number 1, Soumya Anand. for
This
petition
matter
of-
will take up on some other day.
Very,
May not be possible today. We'll have it on, that's why because it is at 2:30 list.
yes.
Court is not sitting at 2:30, that's why it's posted as a first matter. List this matter on 9th at 2:30.
9th, my lord.
9th, yes, 2:30, 9th.
9th, can it be,
Page number,
subject to your lordship's convenience, can it be on 8th, 9th, I have to leave for
Yes,
Amravati?
8th.
Great.
serial number 2, for admission matters, MFS. Page 8.
Interim order,
In the first night.
in whichever matter interim order is
But
there,
one
extend.
submission, if my learned friend has no objection, sir. In 1.2, we have filed an application for amendment. They have not filed any objections. Basically, their documents which we sought under RTI, if that may be allowed, we'll amend our petition and the matter.
On that day.
My lord,
Page
it's
number,
two serial number 4, my lords.
No, no, it's already over now.
Very well.
serial number 2,
Yes.
R. Shashidhara.
Take that.
Yes.
Take it.
Two appeals.
Arising out of the same accident.
Yes, ma'am.
Agreed with the order in both the orders, common order, both the matters. Agreed with the orders passed in MBC number 482 of 2014 and MBC number 483 of 2014 by so and so dated 10th April 2015. The claimants are before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. In MVC 482, it is at paragraph number 28, page number, internal page number 17. In respect of 483, it is at page 24, correct? Internal page 24?
Yes.
Extract the table. Next, in respect of MVC number 482 of 2014, that is MFA number 7229 of 2015, arising out of MVC number 482 of 2000. Keep aside heading. The learned counsel appearing for the petitioner submits that the so where is enhancement? Loss of amenities, medical and other as it is, and loss of income during the later period also is now, how many months it is given?
3 months.
What was the income? Which year is this?
Accident of the year 2013, my lords.
2013, it's 8,000.
8,000.
Court had taken?
Court had taken 6,000.
No, 8,000 into 3 months. Court had granted, but how come it is 13,500?
Additional, my lords. Enhancement.
No, court had granted 13,500. If it is 6 months, it would be 12,000.
Yes.
Well, look at it, what the court has taken.
13,500 is given, my lords.
Let's see, where is that?
Which emission number, my lords? Sorry, my lord. Which emission number, my lords?
Huh?
Emission number, my lords.
MBC number 482.
Please.
Four thousand.
4,500 per month.
But that, how many months it is given?
Lords, regarding the month is not discussed in the judgment, my lord. Only 13,500.
So 3 months it is granted. It is submitted that the court at, when the accident had taken place in the year 2013, instead of taking 8,000 income, court has taken 4,500. Further, it is submitted that the disability sustained by the petitioner is 13%.
13%.
But the court has granted under the head of loss of amenities only an amount of rupees 10,000.
10,000.
It is submitted that the amount of compensation that is awarded by the tribunal is not just and reasonable. Then counsel appearing for the respondent insurance company submits that court has considered all the aspects and has granted a just and reasonable compensation. No interference is called for. Next part. Having heard the counsel on either side, there is a material on record. As the pain and suffering, medical and incidental expenses are concerned, the court has granted a reasonable compensation. No enhancement is called for. Coming to the loss of amenities, considering the disability of 13%, this court is granting an amount of rupees 35,000 under the head of loss of amenities. Then coming to the loss of income during the later period, the court had taken the income at 4,500 as per the charge prepared with the Legal Services Authority. For the year 2013, it is 8,000. Hence, this court is granting 21,000. Altogether, the claimant is entitled for an amount of rupees. Something is wrong with the calculation. Huh?
Ravi Samprati sir calculated.
Huh?
Ravi Samprati sir.
No, what is enhancement now? 15,000 here and another
Future
15,000
loss of
here.
income, my lords, is future loss of income due to disability. 8,000.
But whatever is enhanced, if you look at it here, it is only 13,000, 15, 30,000 is enhanced. Court has granted 2,73,000. Now it has become 4,06,000.
Loss of future earnings due to disability, my lord, is 8,000 into the 30.
But now it is taken as 21,000. With that only,
Future loss of income due to disability, my lords.
there is no enhancement at all in the other aspects. Look at it.
Sir, not given that memo.
Loss of future income, yes. Loss of future income, yes, that I have not said. When it comes to the loss of future income, considering the income at 8,000 and the disability at 13%, 8,000 into 13 into 12, multiply 8,000 into 12 into 18 into 13 by 100 is 2,24,640.
As against 1,30,000.
Now it will be 640. Loss of income I have already written during the later period, 21,000. Altogether, the claimant is entitled for an amount of rupees 4,06,780. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 2,73,000 to 4,06,780. Then coming to the next, this is MFA number 7231 of 2015, arising out of MVC number 483.
484.
No, it is 483, that's what written here.
72.
Now I think if I have made the calculation and done it, it would have been more easy. It is 483 only, not 84.
Yes.
It is 483.
Yes. 7211.
The MFA number 7231 of 2015, arising out of MBC number 483 of 2015. In this also only on the same ground.
Same.
The tribunal has granted the compensation as per the table given below. What you do is, instead of pasting it there, with the side heading, you paste this respectively under the tribunal has granted the compensation as per the table given below. Land counsel appearing for the petitioner submits that the court had failed to take the income at had taken the income at 4,500 instead of 8,000. It is submitted that even at the head of pain and suffering, the amount that is awarded by the court is not reasonable. And for the disability of 20%, the court has granted 5,000 as under the head of loss of amenities. Even at the head of loss of income during the later period also, reasonable compensation is not granted. Hence, the claimant is before this court seeking enhancement. Same like the same contention of the insurance company. This court, having heard the counsels on either side, there is a material on record. Considering the injuries that are sustained by the petitioner under the head of pain and suffering, this court is inclined to grant an amount of rupees 65,000. Coming to the loss of amenities, the disability of the claimant has sustained disability of 20%, and this court is granting an amount of rupees 30,000 towards the loss of amenities. Medical and incidental expenses, court has rightly granted the compensation. Coming to the loss of income during the later period, as this accident had taken place in the year 2013, this court is taking 8,000, whereas the court below had taken 4,500. Under the head, the petition is entitled, the claimant is entitled for an amount of rupees 21,000. Coming to the loss of future income, 8,000 into 12 into 18 into 20 by 100 is 3,45,600. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 3,73,000 to 5,74,700. Both the enhanced amount shall carry 6%. All other clauses as it is in the earlier orders.
Enhanced compensation may permitted.
Huh?
Enhanced compensation may permitted. Enhanced compensation may.
What is that? Enhanced.
Inter enhanced.
As per the terms, whatever it is.
Cell number 3, Murali Babu M for appellant, Ashok N Patil.
Fit for appellant. Order copy.
Take that. He's only on that ground about the
Yes, madam.
liability.
Yes, liability fixed and we go.
It is pay and recovery is applied. Huh? Where do you get that?
Para 7,
Oh,
number
Mukund
7.
Devgan's case. The agreed with the order passed in MBC number 190 of 2013, dated 19 September 2016. The claimant is before this court. Agreed with the what? As on the question of liability, as a tribunal has fixed a liability on the owner of the vehicle. Then counsel appearing for the petitioner submits that the tribunal. Where do you get the liability issue here?
18, page number 18, the page number 10 of the judgment. Page number 10.
10.
Third para.
Paragraph number?
Page number 10, the judgment. The ink page 18.
Ink page 18.
18, 18, ink page number. Para.
I'm asking about the discussion. Where is the discussion with regard to the liability?
Liability, at page number, the issue number 2, para 9. The bottom.
It is submitted that. No, the main contention of respondent number 2 is that the petition was an unauthorized passenger in a goods vehicle.
No, goods was carrying a money,
If you look at
evidence, yes.
para number 9, I'm looking at the order. Huh? No, it's not that. It's not about a connected matter. What is the ground in this case? Why the liability is fastened on the insurance company, the owner of the vehicle? It says he's an unauthorized passenger in a goods vehicle.
Traveling along with goods is a tribunal only on the basis that what you are not holding a valid.
Where is that? That I have to see, isn't it?
Last 4 lines. Therefore, it goes to show that on data taxes, it is 12/1/2013. You are not holding valid license to transport vehicle. Cross examination part of the 1 and 2 has not thrown light on this.
How these kind of orders are. No, if you see, first 3 lines have no connection with the last 3 lines. It is, land counsel appearing for the petition, appellant submits that on the ground that the driver, the respondent number was having a license to drive the LMB non-transport car from 18/7/2007 to 13/5/2026, and he doesn't have the license to drive the transport vehicle, which is valid from, and he has a license to drive the transport vehicle is from 12/6/2013 to 11/6/2013. Therefore, on the date of accident, he was not having a valid driving license to drive the transport vehicle. The court has fixed a liability on the insurance company, on the owner of the vehicle. Land counsel for the petitioner submits that in the light of the law laid down in Mukund Devgan's case, still the insurance company is liable to pay the Mukund Devgan versus Oriental Insurance Company, AR 2017 SC 3668. The insurance company is liable to pay the compensation. Land counsel appearing for the respondent insurance company submits that in the connected matters that is arising out of the same accident, that is MFN number 5442 of 2017 dated 9th January 2023, a coordinate bench of this court has already fixed a liability on the insurance company and allowed the writ petition and allowed the appeal. Appeal having heard the counsels on either side, there is a material on record. In the light of the law laid on in by the Honorable Apex Court in Mukund Devgan's case, the insurance company is liable to pay the compensation accordingly. The appeal of the claimant is allowed by fixing the liability on the insurance company. Same insurance company shall deposit the amount. The interest person.
The submission, deposited, 59,300, and I permitted to withdraw the amount.
Who is the owner of the vehicle?
Owner of the vehicle.
The liability is on the insurance company, and the insurance company shall deposit the amount so and so. The appellant is the owner of the vehicle. Appellant is the owner of the vehicle. The appellant has deposited an amount of, has deposited the amount before this court, an amount of
59,300.
59,300. He is at liberty to withdraw the same. Yes, next.
Number 4, A.N. Krishnaswamy for appellant, Gopal Krishna.
I'm appealing for the appellant, my lordship. This case was settled, my lordship, rupees 11 lakh rupees, my lordship.
Settlements?
Insurance company appeal, my lordship. As per the discussion of the mediation, we settled the amount of rupees 11 lakh. Rupees.
No, you will file it before the
mediation.
Where is that?
It is there, my lordship, kept below in flag A.
Oh. The appeal is filed by the insurance company. The matter was referred to the mediation center, and the same was settled between the parties, whereby the insurance company has agreed to pay an amount of rupees that the insurance company, it was settled that the claimants are entitled for a compensation of rupees 11 lakhs. The 11 lakhs inclusive of interest. And the insurance company has already deposited a sum of rupees 5,40,614 on 13/7/2017, and the difference amount of rupees 5,34,386. They will deposit the same before the tribunal. Within 6 months, 6 weeks, you already deposited.
They already deposited.
Within 6 weeks from the date of acceptance of the agreement by the court. Then counsel appearing for the insurance company submits that already the differential amount of 5,34,386 is
No,
already.
my lordship, the statutory compliance of 5 lakh rupees is deposited in this court.
No,
and remaining
what about
balance
the
will
remaining
deposit,
amount?
my lordship.
That's what I asked. You will deposit.
Yes, my lordship.
The remaining amount shall be deposited within 1 week from today. Within 1 week.
2 weeks, my lordship.
Within 2 weeks from today. Accordingly, in the light of the settlement arrived between the parties dated 25/3/2026, the appeal is disposed of.
Till number 5,
Oblige, my
The
lordship.
amount in deposit shall be forthwith transferred, or he shall be, here it is deposited.
Here it deposited.
You withdraw. The respondent is at liberty to withdraw the amount deposited by the insurance company before this court. Yes.
till number
Oblige,
5, K. Srinivas
For the
for appellant.
appellant, my lords. Claimants appeal, my lords, seeking for
Yeah.
enhancement of the compensation and also as far as the liability is concerned, my lords. Brief
Liability
synopsis.
is fixed on owner of the vehicle.
Please, my lords.
What
Brief
is that?
synopsis, my lords. In this case, what has happened was,
Please come to the table. What are the injuries?
my lords, it is at internal page number 7. Yes, sustained surgical suture wound over the right parietal area of the scalp. And
I didn't get it. 1 minute. Paragraph, where do you get it?
I lost internal page number 7 of the judgment, issue number 2.
Surgical suture wound
measuring
measuring
5 centimeter on right parietal.
grazed abrasion, abraded contusion. All are simple injuries.
My lords, grievous injury because the doctor who has treated was examined as CW2.
Which is a grievous injury?
That is the nerve of the neck has been cut, my lords.
No, 1, 2 or 3.
Second, my lords.
Grazed abrasion measuring on the back of the neck. Surgical sutured wound. How much is, what do you say? Under the head of pain and suffering? That we will decide. That we will decide. Pain and suffering 40,000. Medical expenses as it is?
1,72,000 as per bill.
How many days he was in hospital?
15 days, my lords.
Then court had already granted 27,700. No
Yes.
enhancement. Incidental expenses 27,700. Then loss of disability. Loss of income during later period is not granted.
No, not granted.
Which year is this accident?
2014, my lords.
8,500 into 3.
25,500. 25,500 minutes.
25,500. Then loss of
Future earning, my lords.
loss of future income due to his disability. According to the doctor, what is the disability?
30%. The tribunal has taken at 20%.
30% to the whole body.
Please.
Why the tribunal has taken 20%? Where is the discussion?
That is at next page, my lords. Page number 8.
Page number 8.
Number 8.
Let's read.
Considering the physical disability.
According to the doctor, there was 30% disability. 8 of 12. That internal age. Through this, doctor, read it.
Considering the physical disabilities experienced by the petitioner, as narrated by the doctor in the affidavit, the disability could be considered as 20%. Although the doctor has denied the suggestion that 30% of disablement arrived at in respect of the petitioner was exorbitant, but has not based his opinion on any ground as to how the disablement in respect of the petition was 30%.
Yeah, now, after was going to have 20 documents. Let's say
Let's read it. Let's read it. The
It is relevant in the case as apart from being an expert, the opinion is also based on the grounds. The said grounds in this case are not to be found and CW1 only on the basis of the affidavit filed by him on 17/11/2006 as arrived at 30%. The petitioner, when examined before the court and cross-examined, had all mental faculties were appeared to be in order as the petitioner had responded to the questions during the cross-examination.
What is how he has assessed 30%? As per the settled, there is a manner to assess the disability.
That is not. It is not.
So we will, as it is, we'll go with that. Income is taken at how much?
8,500.
So now on that it will be increased now. Now we are taking it at 8,500 into 12. What is the multiplier?
18, my lords. 18.
18 into 20 by 100. It comes to 3,67,200. Now please come to the liability aspect.
Please.
And loss of immunity is not granted.
Not granted.
Will grant 40,000. Yes, next, please come to the liability aspect.
number 1, page number 10 of
5 of 12, my lords.
Please read that.
The petitioner Issue number one, my lords. The petitioner had reiterated the contents of the petition in the affidavit filed in lieu of his examination in chief. Apart from the oral testimony, the petitioner had also produced as many as 113 documents that were marked as Exhibit P1 to 113. Exhibit P1 is the true copy of the first information. The information of the accident was given by Sri Kritik, son of Shivana Gowda, on 16/3/2014 at 5 p.m. to the Mandya Rural Police Station that came to be registered in crime number 173 of 2014. According to the version contained in the first information statement, the informant Sri Kritik, his friends, the petitioner in this case, and Sri Sachin and Sri Dhanush were having tea at a stall, and the petitioner, in order to have tea on the other side of the Bangalore-Mysore road, was crossing the road when the unfortunate incident had occurred. Exhibit P2 is the true copy of the first information report statement. The informant had shown the spot, and a spot Panchanama was drawn at the spot on the day of the accident in between 5:30 p.m. and 6 p.m. The car in question was seized from the spot while drawing up of the Panchanama. Tire marks were observed at the spot, and the front windscreen and bonnet of the car was found damaged. The car was examined by the motor vehicles inspector on 17/3/2014 and had found front windscreen, right headlight and bonnet damage. There were no other mechanical defects, and the brake system was also found to be in order, and therefore the mechanical defect as one of the cause for the accident is totally ruled out. The register number of the car, as mentioned in Exhibit P1 to P4, is KA20/P0508, and whereas the registration number of the car, as found in the petition, is KA02/P0508. Exhibit P6 is the true copy of the police report filed by the Mandya Rural Police after investigation. According to the investigating officer, there were sufficient material to proceed against the driver of the car bearing registration number KA02/P0508. During the cross-examination, it is denied by PW1, the petitioner, that the accident had occurred when he was crossing the Mysore-Bangalore road, whereas the documents produced by the petitioner himself would show that the accident had occurred 2 feet from the edge of the road and on the tar road. Even during the cross-examination, nothing much could be elicited through PW1 so as to disbelieve the version. However, the witness PW1 only denies that the accident had occurred on the road while he was crossing it. Merely on account it cannot be held that the version of the petitioner is totally unbelievable. There is also an error in so far as the registration number is concerned. Exhibit P1 to 4 would reveal that registration number of the vehicle of the car as KA20/P0508, and whereas the police report, petition and the affidavit would reveal the registration number of the car as KA02/P0508. During the cross-examination, no attempt seems to have been made in so far as this aspect is concerned. The second respondent had not even whispered in so far as this inconsistency is concerned. The petitioner had throughout maintained the registration number of the car as KA02/P0508. Although the petitioner in this case was required to produce the documents, it was also for the respondent number 1 to show by documentary evidence that the report of the police was challenged. On the contrary, the respondent number 2 has performed its part, and therefore, in the absence of any documents to show that the first respondent had challenged the report in view of various discrepancy, that is not sufficiently answered. No doubt the petitioner is held entitled to the compensation.
What is the basis? I'm not able to understand.
Because 20 is the registration is not pertaining to Udupi.
Huh?
02 is the Bangalore registration. 20 registration is about the Udupi. Car number registration itself is wrong. Because that car is not involved.
No. As per the police report, which is the car?
02. As per the
Does it have a registration or not? I mean, does it have the insurance or not?
That is why there is no insurance. That's why we have to.
Where is the discussion on that?
There is no
No,
discussion.
as per the police records, which car is involved?
My lords, KA20/P0508 is the offending vehicle. 508. My lord, what is the difference is, my lords, KA02, KA20. Exhibit P1 is the complaint and P2 to 4 are the.
So now the car, which in the police records finds place, is it insured or not?
My lords, it is insured, but what has happened is, while filing the charge sheet, that is final report, by typographical error or by mistake, the number of the car is mentioned as KA2 instead of KA20. KA2 instead of
Yes.
So by coming to know about the said my mistake, my lords, during the pendency of the proceedings also, when the matter was posted for arguments, the honorable tribunal directed the claimant to produce the B registered act of both the vehicles, and that has been placed before the honorable tribunal also. That are at page number 273 and 272, my lords. And the claimants have also got and filed an application seeking to amend the petition by correcting the number of the car.
What happened to that?
That application was not at all considered. It is
No, this is an accident of which year?
2014, my lords. Instead of disposing the that application, my lords, the judgment has been passed.
But we can't help it.
That is
that's
also one of the
your-
grounds in the appeal, my lords.
No, that might be, but the whole basis is you have not examined any other witness. The whole basis is about the police reports that a particular accident has happened.
Yes.
Police report is disclosing some other car number. You are kept quiet when they have not, taken any steps to change the number. Then that has attained finality, that the vehicle that is involved is so and so, but not the vehicle what you are referring.
My lords, even the B registered act which have been produced before the honorable tribunal also shows that the respondent number 1 is the owner of that offending vehicle itself.
We can't take it into consideration. What about the notice to the owner of the vehicle? So here,
He has placed ex parte.
here, before this court.
Here, the notice was held sufficient by way of paper publication.
Please come. Let me just do the calculation. Agreed with her. Award passed in MVC number 975/2014, dated 4th March 2017. The claimant is before this court, both seeking enhancement of the compensation as well as questioning the liability that is fixed on the owner of the vehicle. The facts of the case are that the petitioner is a student pursuing his BE first year at Sampuro Engineering College. The petitioner, along with his friends, went to the coffee stall near the VC farm on 16/3/2014 at about 3 p.m. They were crossing the Bangalore-Mysore road. And when they were about to cross the road, a car bearing registration number KA02P0508, being driven in a rash and negligent manner, had come from Mysore side and hit the petitioner, causing the accident. The court has held that the accident had taken place because of the rash and negligent driving of the driver of the vehicle. The whole dispute here is about the number of the car. According to the petitioner, it is KA02B0508. And basing on the complaint given by the petitioner, the police KA02/P 0508. And basing on the complaint given by the petitioner appellant claimant, the police have filed the charge sheet. And the charge sheet is filed against a vehicle KA20/P 0508.
My lord, sir, FIR was registered for KA20. Charge sheet was filed for KA2.
The police have, your complaint is on that.
KA20 only.
The complaint is on KA20.
KA20.
Charge sheet filed on
KA2.
02.
Not 02, only 2.
That's not correct. What you say is KA2. In your complaint, come to your facts of the case.
My lord, sir, by seeing the contents of the FIR, my lords, the petition has been filed stating that the vehicle number is KA2.
That's what your petition is also.
Petition is also like that only, but by.
But that's what we have to write, the KA02/P0508. The police but exhibit P1 to 4 revealed the registration number of the car KA20P or 20/P0508. And whereas the police report, petition and the affidavit would reveal the number KA02P0508. The court has observed that the petitioner had throughout maintained the registration number of the car as KA02P0508. Ultimately, which is the car? What this disturbance? I'm not.
KA20 only.
Now the charge sheet is filed on 02.
02. It is not stated as 02. Only 2.
The charge sheet is filed on KA2. Considering all this, the court. Then when there is a discrepancy, when owner is liable to, that car is not insured.
Lord, it is insured with the.
Not 20, 2.
2
is not insured.
No, we are not.
As considering the fact that throughout KA2 is a number that is stated in the petition, in the police reports. The court has held that as the same is not insured by the respondent, the insurance company, the owner of the vehicle is liable to pay the compensation. The owner of the vehicle remained ex parte before the trial court, and even before this court also, the notice to him is held sufficient. Land counsel appearing for the insurance company submits that the court has rightly considered all these aspects and rightly held the owner of KA2 to KA2P0508 to pay the compensation. Next, land counsel appearing for the claimant submits that the liability ought to have been fixed on the owner of the vehicle, as the vehicle that is involved in the accident is KA20P0508. But the court, without considering all these aspects, has fixed a liability on the owner of the vehicle, that is KA02P508. Further, it is submitted that under the head of pain and suffering, the amount that is awarded by the tribunal is not a reasonable compensation. And coming to the loss of income during the later period, court had taken the income as
6,500.
6,500 instead of 8,500. And when the doctor has reported that the disability is 30%, court had taken 20% as disability, and no amount is granted on the head of loss of amenities. And on all these grounds, the petition is in the compensation needs to be enhanced. Having got the counsels on either side, there is a material on record. Coming to the aspect of liability, as rightly observed by the court, and as the court has rightly come to the conclusion and fixed a liability on the vehicle KA2P0508, as it is a consistent case of the petitioner that the said vehicle is involved. It is submitted that in fact they have filed a petition to seeking correction. However, the said correction is not made and the judgment is pronounced in the criminal case. In view of the above, in view of all these discrepancies, and as the K02P0508 is not having the valid insurance, court has rightly fixed a liability on the owner of the vehicle. Then coming to the compensation, considering the 4 injuries and 1 previous injury that is sustained, under the head of pain and suffering, this court is granting 40,000. Medical expenses and incidental expenses, no interference is called for. Coming to the loss of income during the later period, as this accident had taken place in the year 2014, this court is taking 8,500 into 3, 25,500. Then coming to the loss of future income, The court had rightly considered the disability at 30% as evidence of the doctor. The doctor, considering the evidence of the doctor, the court had rightly taken the disability at 20%, but not 30% as deposed by him. Hence, taking the income at 8,500 into 12 into 18 into 20 by 100 is 3,67,000. Considering the disability of 20%, this court is granting the loss of amenities at 40,000. In the light of the law laid down in Meghalaya towards expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,82,400. Accordingly, the appeal of the claimant is partly allowed. Enhance the compensation from 4,90,500 to 6,82,500. The enhanced amount shall carry interest at 6%. The amount the owner of the vehicle is liable to pay. Yes, next.
Cell number 6, Raghu R. for appellant.
Case of injury, my lord.
P. Pradeep.
Page number 13 of the judgment, my lord. Injuries, my lord. Head injury, please.
1 minute. Where is the table?
Table, my lord. Table at page number 23, my lord. Of the judgment, my lord.
Page number?
23 of the judgment, my lord. Table. And injury at page number 13 of the judgment, my lord.
What are the injuries sustained?
Page number 13 of the judgment, my lord. Head injury with minimal subarched hemorrhage, frontal region, fracture of mandible, fracture of bimaxial sinus with displaced fracture of wall of right orbit.
What do you
Fracture
say? Parents suffering?
1,000 is given.
And
Totally
another 25?
6 ribs.
No, but head injury and other grievous
Fractures,
injuries are there.
6 fractures.
6 fractures. So if you take at least 10,000 for each fracture, 60,000. And what about the head injury? I think it will. Will grant another 10,000, 85,000. Then what is the other head? How many days he was in hospital?
15 days, my lord.
Reasonably granted.
Medical expenses as per the medical expenses given, my lord.
16,000.
Loss of income during treatment period, my lord. 6,000.
Medical expenses?
As per the medical bills, my lord.
1 minute.
5,69,041, my lord.
5,69,041.
Loss of income during later period, my lord. 6,000 is income taken, my lord.
How much it should be? 7,790. That we will take.
7,790, my lord.
7,790 into
3, my lord, 15 days inpatient, my lord. There, the court has given 3 months, my lord. I leave it, my lord.
3 or 4 months. So same, we'll grant
4
4
months.
months, 7,790. Yes, loss of future income.
My lord, taken, my lord. Doctor stated 33% disability to the whole body, my lord.
Court has taken 25%.
25%.
What is the reason?
40% to the hand and 40% to the
60% to the.
weight. Only hand disability they have assessed.
So 40, that is, we have to take 10%. So how it will come? 40?
Photos already produced, my lord. Yes.
So 13% and another is 60.
The same limb, the doctor has said only same limb 48%. Can you see that?
Because of that, he is having.
So how can there be for only one hand, two kind of disability?
Photographs are produced. His hand is cut here, my lord.
No,
Photographs is
disability, when he
produced.
says 60%, it would be to the entire limb, that left.
60% to the limb and 40% to the hand, my lord. Because of that, my lord, he has.
No, that's whole limb is one.
Yes, my lord.
One hand.
Because he has not put.
No, whenever you assess the disability.
Yes, ma'am.
You assess the disability to the limb, either it is left hand, right hand, or to the leg.
Yes, ma'am. Doctor assessed.
But it can't be for the leg, two disabilities, it can't be for the hand.
For hand component, he says 60%, my lord. Left shoulder component 40%, my lord. Like this, doctor stated.
But the assessment should be to the hand when they.
33% to the whole body, 25% is taken, my lord. It may be.
And only this
Future parts may be
income
added.
aspect, we will 7,790 into 12 into.
Future parts may be added, my lord.
mul- How much is taken?
25% is taken, my lord.
Then future prospect will take. What is the age?
17 multiplier taken.
790 into 40. It comes to 3,116. It comes to 10,906 into 12. Multiplier is 17.
17, my lord.
Into 20.
25%.
It comes to 5,56,206. Loss of amenities, how much is granted?
30,000 is given, my lord.
How much?
30,000 is given. And future
Disability of 25%, yes. So,
future medical expenses 20,000 given.
so
my lord.
55,000. Future medical expenses?
20,000 given, my lord.
Yes. It's coming to 13,42,407 against 10,40,041. Yes, please come. Agreed with the award passed in MBC number 1126 of 2016, dated 27 January 2016. The claimant is before this court seeking enhancement of the compensation. Next one. The tribunal has granted the compensation as per the table given below. At page 23, internal page 23. Then counsel appearing for the claimant submits that the claimant had sustained as many as six fractures, 6 previous injuries, and also head injury, and the court had granted only 75,000 towards pain and suffering. Coming to the loss of income, it is submitted that the court has taken only 6,000. Court ought to have taken, which year is the accident?
2014.
Court ought to have taken 8,500 as the income. It is submitted that when the doctor has reported that the disability is
33% to whole body.
35% to the whole
33,
body.
my lord.
33% to the whole body. Court had taken 25%. And under the head of loss of amenities, the amount of the compensation that is awarded is not just unreasonable. Expert and counsel appearing for the, and it is submitted that the compensation needs to be enhanced. Then counsel appearing for the respondent insurance company submits that the tribunal has rightly considered the disability at 25%, as the doctor has given that to the part of the shoulder, to the left hand, one disability, and to the other part, the remaining disability, it cannot be, and it has to be that's why the court had rightly taken 25% as disability, and there is no interference called for. It is submitted that according to the claimant himself is earning 7,790. Question of taking 8,500 will not arise. It is submitted that on all the counts, the compensation that is awarded is just and reasonable. Next, having other counsels on either side, there is the material on record. Considering the injuries that are sustained by the claimant and the head of pain and suffering, this court is granting 85,000. Incidental expenses, medical expenses, court has rightly granted. No interference is called for. Coming to the loss of income during the later period, considering the chart, it is 8,500, but according to the claimant, is earning 7,790. And this court is taking the income at 7,790 into 4, 31,160. Coming to the loss of future income, as rightly argued with the learned counsel appearing for the insurance company, the court had rightly taken 25% and that the manner in which the disability is assessed by the doctor is not correct. Hence, at the head of loss of future income, but the as it is 25% disability, this court is inclined to grant 40% future prospects. 7,790 future prospects at 40% comes to 3,160. That is 10,906 into 12 into 17 into 25 by 100 is 5,56,206. Towards loss of immunities, considering the 25% disability, this court is granting 55,000. Future medical expenses, court had rightly granted and no interference is called for. In the light of the law laid on in Mekala, 10,000 legal expenses. Altogether, the claimant is entitled for an amount of rupees 13,42,407. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 10,40,041 to 13,42,407. Accordingly, the appeal is partly allowed and the enhanced amount shall carry 6%.
Cell number 7, Chetan Nag.
The appellant. File the appeal challenging the.
Who appeals for the respondent? Where is Mr. G. Vijay Kumar Nagarajaya for DAR2? It's a matter, it's for enhancement?
Yes, madam. Quantum of compensation, my lord.
Quantum of compensation. There is no representation on behalf of the respondent. Counsel for the appellant is present. This is matter as part heard on next Friday. That day we'll hear. Otherwise also we'll pass orders.
Yes.
No, yes. For the counsel for the petitioner appellant in part, no representation for the respondent. This is matter as part heard on next Friday. Give the look at the date and give.
Cell number 8, O Mahesh.
I appear for the appellant, my lord. I request for an adjournment because I have to go for an annual medical checkup, my lord. All my matters may be accommodated, my lord, after 2 weeks, my lord.
Yes, please after 2 weeks.
Lord, please.
Let's take.
Cell number 9.
Serial number. Holiday. And then it should be that the coming Friday.
10-4.
Yes,
In serial number 9, my lord,
yes.
there is one cross objections filed by me and another appeal is filed by Chandrasekhar.
You're on what ground?
I have filed the cross objections on the ground of non-involvement of the vehicle. Case, we contested the proceedings. That was not on that ground. We contested the proceedings on quantum and it was contended that the injured claimant was an occupant of the auto rickshaw. An award was passed. Then they filed an appeal before the High Court. The matter was taken up before the Lok Adalat. In the meantime, they have collected the information and came to know that the injured was not an occupant, but he himself was driving the
But
vehicle.
how will a cross appeal lie now?
Because now these new facts have come to our.
That's not a ground for a cross appeal.
I had to file another appeal, but
Not another appeal. Because now what is going to be decided by this court is what has transpired in the court. No, it's all, you're going to the fundamental issue of the involvement of the
Supreme
vehicle.
Court
No,
has said that,
whether it is open for the insurance company or for this court.
Yes, in Rajendra Singh case, the Supreme Court has held that in spite of the company insurer coming to know at a later stage that an award was surreptitiously obtained and by playing fraud, that does not deter the courts from.
But not by filing an appeal.
That's the only remedy which I have got. Yeah, I'll verify that position.
Please verify. This is matter after 2 weeks. Yes, 10.
Along with CROB, sir.
2 weeks.
CROB number.
And there, and another thing is I have to
Three,
take
2 weeks.
steps.
It is this.
Yes.
Cell number
I may
10.
steps may be ordered, I'll take the steps. In cross objections.
Oh,
In the meantime,
the applicant shall take, in MFA crop, the steps shall be taken for issuance of notice to the respondents. Yes.
Cell number 10.
Appearing for insurance company appellant, my
Sitaram
lord. Lord, this is a case of liability only policy, my lord.
Liability only policy.
Liability only policy.
Where is the counsel for the respondent? No representation for the, for the respondent. Counsel for the appellant is present. Heard the counsel in part, list it as parted, give the
Heard.
date.
It may be heard, my lord.
17.
Maybe take.
What do you want?
Nothing.
Yes.
17. Cell number 11. Cell number 11. Raja Ramesh. A. Krishna Swami.
Advocates are not coming forward to argue 14 appeals. So unfortunate. What is the matter? Yes, 11.
11.
Krishna Swami, you're for R2 in 11. Do the file. No representation on behalf of the appellant. Counsel for the respondent is present. This is matter as parted on the same date.
17. Cell number 12. Cell number 12, O Mahesh.
Yes, this also.
Appear
after
for
2
the
weeks.
appellant, Mala, the
2
connector
weeks.
matter.
You heard his submission that he is unwell.
Yeah.
2 weeks.
Date may can be other, Mala, this matter is case of death.
After 2 weeks, it's a case of death.
Case of death. Old matter and for the one other reason he is taking date. Date may can,
We'll have it on 24th.
24.
please.
24. Cell number 13. O Mahesh.
This also.
24. No?
Yes.
Cell number 15.
14.
Cell number 15.
14, what happened to 14?
14 also O Mahesh. 14. Cell number 14. Kumar Ranjit.
This also parted on 7/27, 17, whether they are there or not, we'll pass orders on the day.
Cell number 15.
I appear for the,
Venkatarama case.
I appear for the appellant, my lord.
Yes.
In this case, two appeals are there. One is filed by the respondent before the trial court, another is for the appellant. Cross appeal is there. I am appearing for the owner of the vehicle, my lord.
In first one, MFA
Yeah,
4394.
MFA number 4394, I appear for the
Crop is by the claimant.
claimant.
Liability is fixed on you.
Liability fixed on the owner of the
On the
vehicle.
ground?
On the ground stating that actually the two brothers of the vehicle were driving. One is Muhammad Wasi, another is Muhammad Ois. The person who is having a license was the driving. At the time of taking the signatures, he has taken the another brother's signature who is not having the valid license.
Who has taken the signature?
Signature was taken by Muhammad Ohis Ahmad. His signature has been taken in the police station, stating that he is the driver. Actual driver is Mr. Muhammad Mes Ahmad, who was also made as a party in the charge sheet as a
Oh,
witness.
correct. As per the charge sheet,
As per the
who
charge
was
sheet.
driving? The person having a driving license or not having the driving license?
They have made, actually person having a driving license was driving.
Not your case. As per the charge
As
sheet.
per the charge sheet, they have taken the other brother's signature.
Then unless and until you adduce any other.
I have
other
adduced
independent-
my evidence and I have produced my driving license.
No, here the issue is not about your driving license. Who was driving the license at the relevant point of time is the question. Charge sheet shows that somebody else is driving. If according to you, the charge sheet that is filed against so-and-so is bad, you could have questioned that.
I could have questioned it because it has been settled by the, before the police
Then
stating that it
if
will
it is
be.
settled,
But they have settled in a manner where that entire thing has been false liability on the Muhammad, the person who is having no license. That way they have closed it under impression that once the case has been closed in the police station, of course, Ignorance of law is no excuse, I can understand, my lord, but only things, what are the facts it has been happened
That's
in this
true, but
station,
we
that has
can't
been happened.
appreciate, we
So
can't
under while license was there, and moreover, the insurance company has given own damages to the both the parties. That be the case, at least they should have pay and recovery also can be done.
Owner can't ask for pay and recover.
I can't, but they have done it, my lord, like that. In the evidence also.
Claimant is asking it, that we will, anyhow claimant's appeal is there.
Yes, yes.
There we will say pay and recover.
That's what, if they ask it, because there is evidence is there by the respondent insurance company.
No, as far as your appeal is
No,
concerned.
I agree, my lord. If they will,
Your
they
appeal
will,
is over.
No,
No,
they will
we have
also
to
ask.
look at the claimant's appeal. Where is Mr. Puttaswamy?
Appear for the claimant, my lord.
Yes.
There is a cross objection regarding the for the pay and recovery, and some my enhancement is there, madam.
Let's see.
Yes, ma'am.
Give the file.
Kindly, the evidence of the respondent number 1, 2, my lord.
In your appeal, it's all more of, nothing will, no, it won't make any difference. Come to the compensation.
One more point is, in case my friend is also telling that pay and recovery, at least for his case, not in my case, even if it case.
So that it will be granted.
That it will.
If in case it will be granted.
Yes. If that is there, then it will be subsequently there. Okay. Next point
Come
is.
to the, where is the table?
Table at page number 22 of the judgment, my lord.
Judgment page number.
So please come to page, this pain, what are the injuries?
Injuries are.
Multiple head injury, my lord.
What are they? How many?
Traumatic brain injury, left parietal occipital extradural hematoma, and he was admitted for almost 1 month in the BJS Global Hospital, my lord.
No, please come to that, the discussion in the judgment with regard to the injuries.
Yes, my lord.
Para number 42.
Ink page number 28, printed page number 18.
43, my lord. Page number 19, para number 43, my lord.
It appears that petitioner suffered traumatic brain injury, left parieto-occipital extradural hematoma and right frontal temporal contusion, as well as fracture of left occipital bone extending to left mastoid, which are grievous in nature. 31 days.
Yes, my lord. 31 days in a first inpatient, 7 days and.
What is the disability according to the doctor? Court has incidental expenses already 50,000 is granted. No enhancement is called for. No disability. Laid up period. Which year is the accident?
2010, my lord.
But already on loss of income also, court has granted constable amount 50,000.
Yes, ma'am.
Where is he? This needs to be reduced because his appeal is there.
And
Yes,
50,000.
How can it be? How the court can grant this loss of income during when you are in 38 days? How should it be 50,000?
Inpatient is for 38 days. Follow-up treatment
So,
was actually there was no
incidental expenses, we will make it 38,000.
but exhibit P8 disability certificate has been produced by the doctor where
One
it has
minute.
said.
So, no, we'll go step by step.
Yes, my lord.
Incidental expenses 38,000. Then loss of income during the later period. This accident has happened in the year 2010. The income is 5,500. How many, even if we take for 5 months also, it would be 5,500 into 5 months.
125 plus 25, 150.
It comes to 27,500.
Yes, madam.
No, please come to the doctor's evidence with regard to disability.
Exhibit P8, my lord.
You have not examined anybody.
No, madam. No, my lord. Just a disability certificate has been given by the ENT surgeon for
But
a loss of.
we can't consider it without examining anybody. Court has rightly not considered. Loss of amenities already 50,000 is granted. Yes.
Loss of marriage prospects, but till today he has not yet married. Since because of the
The
loss of.
problem is without you examining the doctor, without the court understanding what is a disability, how will the court consider that there is you require compensation under that head? It comes to
Parent
some.
suffering, sir. The enhancement in parent suffering because severe head
Already
injury matter.
it's granted another 20,000.
Yes, my lord.
It comes to 7,15,500. Now it
Yes,
has
ma'am.
come down from 7,30,000 to 15. The agreed with the.
My lord, one more submission, my lord. Regarding that exhibit P18, a letter has been issued by the employer. He has paid 50,000 extra.
Who paid?
Employer of the injured. He has already paid 50,000 rupees.
Is it
Employer, no, my lord. Employer has given in as a humanitarian ground for him for this one. That has not been paid by the R1 to claim for the compensation. It was the
You can
employer.
understand you are the employer.
Yes, ma'am.
But you are not.
No, I'm not the employer.
He is not
You
the
are
employer.
agreed with the award passed in MBC number 4281 of 2011. Dated 10 February 2015. The owner of the vehicle as well as the claimant sought before this court. The owner's appeal is MFA number 4394 of 2015. Five, seeking compensation. Compensation for the injuries sustained by the claimant in the accident. Is a case of the claimant that on 4/11/2010 at about 12 p.m. he was proceeding as a pillion rider on the motorcycle from Mysore towards Bangalore on the left side of the BM road near PWD Circle, Ramnagar town. At that time, the rider of the motorcycle came in a high speed in a rash and negligent manner, dashed against the two-wheeler, because of which both the riders fell down and sustained injuries. The tribunal has fixed the liability on the owner of the vehicle as the rider of the offending vehicle is not having a valid driving license. Land counsel appearing for the claimant, the owner of the vehicle submits that, in fact, both the brothers are proceeding on the motorcycle. When the brother who is having the license was driving the vehicle, but unfortunately, in all the police records, it is mentioned as the other brother who is not having the driving license is riding the vehicle. As such, the tribunal has fixed the liability on the owner of the vehicle. It is submitted that these aspects were not properly appreciated by the court. It is further submitted that the compensation that is awarded by the tribunal is not just is on the higher side. and the same needs to be, the compensation needs to be reduced. Then counsel appearing for the claimant submits that
For
the
a moment, for a moment, that exhibit P18 may be seen. The company has paid 50,000 to meet out medical expenses under humanitarian ground. They have specifically mentioned it is for medical.
submitted that
yes,
the company
it's the
has already
employer.
paid 50,000 rupees under the humanitarian grounds. As such, that amount needs to be deducted. Then counsel appearing for the, claimant submits that the court has not granted a just and reasonable compensation. When he has sustained those many grievous injuries, the court has not granted a reasonable compensation. On all counts, the compensation needs to be enhanced. It is submitted that he has placed a disability certificate, but the court has failed to grant any amount under the head of loss of disability, in loss of income due to disability. It is further submitted that when it comes to the liability of fixing on the owner of the vehicle, it is submitted that though the rider of the vehicle is not having a valid driving license, in the light of the law laid down in Forensics case, still the insurance company is liable to pay and record the same from the owner of the vehicle. Owner of the vehicle. Next paragraph. Having heard the one more submission. It is submitted that his employer paying an amount of rupees 50,000 to the petitioner would not exonerate the owner of the vehicle from paying the amount, and that amount cannot be deducted from the compensation. Next paragraph. Learned counsel appearing for the insurance company submits that the court has fixed a liability, rightly fixed a liability on the owner of the vehicle, and there was no driving license to the rider of the vehicle, and the insurance company is not liable to pay the compensation. Next, having heard the counsels on either side, peruse of material on record. The first coming to the aspect of first coming to the aspect of liability, the entire police records show that the rider is not having the driving license. According to the owner of the vehicle, the other brother who is having the license is driving he was driving the vehicle. There is no, the entire case revolves around the police records, and the self-serving statement of the parties cannot be taken into consideration. And above all, in this case, they've already compromised in the matter, wherein the rider who is not having the driving license is accused in the said FIR. In those circumstances, this court is not inclined to interfere with the finding of the tribunal with regard to the liability on the owner of the vehicle. Then coming to the contention of the land counsel for the claimant, even though there is no driving license, still the insurance company is liable to pay the amount and report the same from the owner of the vehicle in the light of the law laid down by the apex court in Forensics case. In that view of the matter, the insurance company shall pay the compensation and record the same from the owner of the vehicle. Then coming to the compensation, considering the injuries, the head injury and the other injuries sustained by the claimant under the head of pain and suffering, this court is granting 70,000 towards medical expenses. This court is granting an amount of rupees 5. The trial court has already granted 5,30,000. There are no grounds to interfere. Then coming to the incidental expenses, he was in hospital for 38,000, but the court had granted 50,000, and the same is reduced to 38,000. Coming to the loss of income during the later period, this accident had taken place in the year 2010. 5,500 into 5 comes to 27,500. Hence, this court is granting 27,500, and the amount of 50,000 that is granted by the court is reduced. Then coming to the loss of income during the loss of future income.
One submission, my lord. Payslip has been given, my lord. 8,750 has been produced. Payslip.
8,000?
750, my lord.
Then in that case, as it is, 50,000. as granted by the court. Another 22,500 needs to be added to this. 10, 8, 3, 7,000, 7,38,000. The, as far as the loss of income in the disability is concerned, this court does not interfere. Coming to the loss of future income due to disability, the petition, the claimant had not examined the doctor. The court had rightly considered, lightly not granted any amount. However, towards the amenities, court had granted 50,000 and this court is not interfering with the same. Accordingly, the claimant is entitled for an amount of rupees 7,38,000. The appeal of the owner is dismissed. The appeal for the cross objection filed with the claimant is partly allowed, holding that the insurance company is liable to pay the compensation and record the same from the owner of the vehicle, and the amount of compensation is enhanced from 7,30,000 to 7,38,000. And in the discussion part, it is submitted that the employer of the claimant has paid an amount of rupees 40,000. 50,000. Even if the amount is paid, it would not, the said amount cannot be deducted from the amount which the owner is liable to pay. Yes. Accordingly, the appeal is the cross objections are partly allowed. The insurance company shall deposit the amount and record this.
We have, in view of taking stay, we have paid the amount, 50% amount was already paid.
That will be transferred. The amount in the deposit shall be transferred. Remaining amount shall be deposited by the insurance company.
The 50%, my lord, they have paid only the award amount. The interest part has not been paid, my lord.
Whatever it is.
Whatever it is.
Much of it.
Instead of saying 50%, the remaining amount shall be paid by the insurance company. What is that? Crop is allowed, partly allowed.
Much of
dismissed.
Much of.
Cell number 16. K. Lakshmi Rao.
Lordship, this is KSIT's appeal on the ground of questioning the compensation amount, not a negligence.
Give that.
The award passed by the Honorable Tribunal is
come to the table.
Page number 7 of impugned judgment. It's pain and suffering, 1 lakh, medical and incidental expenses 50,000.
Pain and suffering. Yeah. What are the injuries?
It's one fracture and left femur fracture, and it is united as per the medical.
Isn't it 1 lakh on a higher side?
It's on higher side. 12 years and
that
Mallikarjun,
how much it will come? What is the disability?
It is disability is Lordship, disability is 20.
Who is the author of the judgment? That's what I see in the judgment.
Lordship, I'm producing the Mallikarjun case, and
if
in
you
this
want, will legend the matter. And granted how much? Granted how much? Like in case of like any adult. Yes. Agent. This is matter in a month of June.
Cell number 17. 17 Gunashekara.
On behalf of Gunashekar, my lord, kindly, on behalf of Gunashekar, my lord, kindly, week's time, my lord, kindly after 8th, my lord.
Please understand, MFAs of 2015, if you're asking for time,
Lord, I apologize, my lord.
To your client and their client both.
Kindly on 8th, my lord, we will complete it.
June. No matter will come back again in the list. Because whoever are ready, I'll hear those matters only.
Cell number 18.
Huh? Yes.
18.
I appear for the appellant, my lord.
Yes.
Suresh K.
Yes, ma'am.
On what ground you are before the court?
Challenging on the ground of liability and quantum, my lord.
Liability, what's the ground?
Yes. The accident has happened while
The claimant was, the petitioner was riding the bicycle. The case alleged is that
Or the land counsel for the insurance company in part, no representation on behalf of the respondent. This is matter as part heard on same date.
24.
Yes.
Cell number 19,
19 or
HS Lingaraj, 24.
Appeal 14. Appeal is by the insurer challenging the liability. Well, my main ground of challenge is that in the FIR, the name of the accused is shown as one Ravi, but ultimately the charge sheet came to be filed against one Shukumar Jadar. The police do not say how this they have come to know about this. Shukumar Jadar was the driver of the vehicle. The accident occurred due to collision between motorbike and Tata Ace. I am the insurer of the Tata Ace charge sheet. My
Tata Ace is driven by.
insured with my way.
Is driven by the driver
One
of your.
Ravi, as per exhibit R1 complaint, but ultimately the charge sheet is filed against another person. I have
Vehicle is the same.
Pardon?
Vehicle is the same.
Vehicle is the same. No, I'm not about. And I have examined the Shukumar Jadar also. He is acquitted in the criminal court. He says I was driving. He before the MSCT comes and says I was driving the vehicle and all. But he says in the cross examination says the person who was driving the vehicle was the same person as shown in the FIR. FIR is a different. One is Ravi. That's the only contention which I
They cannot challenge the charge.
I cannot challenge it. Charge sheet is
insurance
entered in
company cannot challenge
acquittal.
it. No, what is why initially that person's name is found place and later why it is changed? There should be some reason for that. Huh? Paragraph number?
November 2007-19.
Let us read. Owner of the vehicle is examined. Hmm.
हो गया
No, charge sheet is part of this. Charge sheet is marked.
Charge sheet is marked.
So in the charge sheet, FIR is registered against one person. Charge sheet is filed against another person. So the charge sheet would reveal that.
Except his name, nothing is. I have got, but that's not.
They should. Why will they prove? Because they are not parties before the criminal. No. Every charge sheet, no. FIR says somebody's name and charge sheet is somebody else. They will say that during the course of investigation, though initially the FIR is against so and so, later after investigation, so and so, it revealed that he was driving the vehicle. Something would be there in the charge sheet. Suddenly, the name of the accused won't change. At least for that 161 statement, something you should have filed. FIR. After that, 161 statements will be there, isn't it? Probably the Ravi Kumar was not having the
DL.
DL, and this person is having the DL, so it is changed. That's for you to prove, because charge sheet is, FIR is on somebody, charge sheet is on somebody. Huh?
Charge sheet is ended in acquittal of Shivkumar Jada. He had to contest, he has contested, and that has ended in acquittal.
At least now, by way of additional evidence, place something before the court with regard to that, why the name is changed. Then I'll set aside this order and I'll remand it for examining the investigating officer. That's a glaring aspect, isn't it? When you are also, when, that's why that's not possible to, that raises any amount of doubt in the mind of the court. It raises any amount of doubt in the mind of the court with regard to the incident, with regard to who is driving the vehicle. Why it is changed? At least there should be something from one person to the other person. Somebody is accused in the FIR, somebody is accused in the charge sheet. Why it is changed? Post after 2 weeks. 2 weeks. 27. What is the date? Yes. Next.
Cell number 20. Cell number 20. SV Hegde.
My lord, I appear for the appellant, my lord. Appeal of the insurance company on the question of liability, my lord.
Yes.
My lord, my lord, the vehicle involved in the accident was a tractor trailer fitted with, my lord, water tank. My lord, the vehicle weight, combined vehicle weight is 8,000 odd, my lord. My lord, the person who was driving this vehicle, the evidence on record shows he had driving license to drive light motor vehicle up to 7,500 kgs. So, my lord, accordingly, my lord, our contention is in view of this, we are not liable to pay the compensation. But, my lord, your lords may kindly pass an order for pay and recovery, my lord. The petitioners are third parties, my lord. Discussion is at paragraph 26, my lord, page 14.
No, with regard to the, you have raised two contentions. One is with regard
Yes,
to
my lord.
the driving license.
Driving license.
And the
Yes,
other one is?
my lord, only that is the main contention, my lord.
You said something else with the tractor trailer or something.
Only,
You
my
said.
lord, the vehicle involved in the accident is a tractor trailer fitted with a water tank. My lord, this vehicle is the deceased, my lord.
If that is fitted, whether the insurance company on that aspect also we have to look into whether they can
Yes,
fit
my
the
lord,
water tank.
my lord, your lords may kindly appreciate. We have led the evidence of the RTO also. RTO also speaks about, my lord, the petitioner cannot, the driver who are driving this vehicle cannot drive the vehicle which is more than 7,500 kgs. Apparently, my lord, this document shows, the RC book and other things shows, my lord, the vehicle involved in the accident is around 8,000. My lord, I'll submit that. Trailer is, my lord, around, my lord, 6,250 kg, 60 kg, and my lord, trailer is the tractor is weighing about 1,820 kgs, my lord. Accordingly, my lord, the petitioner, my lord, the owner, my lord, he entrusted this vehicle to a person who had no driving license to drive a transport vehicle. Once a tractor and trailer is combined together, it will amount to transport vehicle. He doesn't have the transport endorsement to drive this vehicle, my lord.
What is Mukundevan's judgment?
My lord, Mukundan Devan case is not applicable to the facts of this case, my lord.
Why?
My lord, Mukundan Devan speaks to only up to 7,500 kgs, that will
That is
amount
what happened
to
with the
light. Yes, my lord. Here
7,500.
total weight of the.
Unlighted weight is 1,820. And whereas in the trailer, exhibit R3 is stated for the trailer agriculture purpose. So unlighted weight is 1,000.
No. He says that
Combined
they
weight
examined somebody and he said that it is 10,000 or something.
My lord, the combined weight of this vehicle is, my lord, 8,420 kgs, my lord.
8,000?
8,420 kgs.
Whose evidence is this?
My lord, the RTO's evidence is there. And also, my lord, this we have produced this DL extract as well as, my lord, this RC book also we have produced. Your lords may kindly
RTO's
appreciate.
evidence is examined as
Yes, my lord. He also speaks
RW.
about this. RW, my lord, RW3, my lord.
As far as transport endorsement is concerned, covered by,
Yes,
but at
madam.
the same time, vehicle's weight is also one of the factor in that case.
That is the main
According to
fact, my lord, as per the Mukundan Devan case.
Mr. Murugan, either you have to come to the court or you have to follow.
So, your lord may, sorry.
It is 8,420 as per the evidence of the RTO. Huh? What is not put up? It's not there. The registry is directed to place the TCR, list it on the next date of hearing.
24. Number 21.
Yes, after 2 weeks.
21.
After 2 weeks.
2 weeks. 22. Sitaram Rao, BC.
22, my lord, short accommodation next week, my lord, date may be given.
Yes, this matter after 3 weeks. Yes, 23.
24.
This
Yes,
also, entire list is his matters only.
2 weeks. 24 urgent.
Yes.
25 urgent. Cell number 26. SV Hegde Udlamani.
My lord, 26 and 27 also, my lord, the next date of hearing I will argue the matter. Only the question is liability, and it's also covered by my lord Lalmati's case, my lord. I will place before your lordship, my lord, that judgment.
28.
24. Cell number 27.
27 also same. 28.
28
madam.
and for
Ravi,
insurance
Ravi.
company please.
Huh?
Insurance company appeal please.
Where is the counsel for the respondent?
Mustaq Ahmad.
25.
28. Mustaq Ahmad.
Other side.
On what ground insurance company is
My
before?
lord, is the deceased, the LRs now deceased, claim petition filed by the mother and major brother of the deceased please now. Later she died, mother is also died. Mother, her daughter has been brought on record. Her father is entirely different in this case. He, father of the Jayam, husband of the name of Ganga is Gangaya. The daughter brought on record the name of the father's name is entirely different, Basavaraj. Now only brother is survived by the deceased. Not entire loss of dependent, loss of estate, some amount can be given.
This is partnered. No representation for the respondent. Heard the counsel for the insurance company in part. Yes, next.
4. 29. Cell
Serial
number
number
29 urgent.
I'm sorry,
30.
my lord, I want to make submission. Serial number 25 is posted today. Last occasion also it is not reached, but today it is a very simple matter regarding a light motor vehicle and light goods vehicle.
Some difficulty they have expressed in the morning and made a mention.
My only
List
short
is matter on that as partnered. List it at.
already one judgment, common judgment has been challenged by
But
this.
anyhow, they have made a mention. That's why I'll take it up on the next day. No, we can't do anything. They've already asked for the adjournment in the morning. I'll take up on the next date. Yes.
24 already.
Yes,
ಈ month.
59 urgent.
Yes.
Next month.
30.
Yes.
Cell number 30. E. Sitaram Rao.
Hearing for
Yes.
next week, my lord.
Why you're asking time?
Senior is went to another some.
The difficulty is all of you file appeal, insurance company files appeal and you obtain a stay. What will happen to them?
No, my lord. We are ready for arguments. Please.
That's what I'm saying.
We'll finish it next hearing, my lord. Kindly.
And please, I'm telling you, never, from next time, I'll not expect any of the insurance councils to ask for adjournment. If they ask, I'll dismiss it on the ground. This also on the next date of hearing.
24-4. Serial number 31. 31. Manjula N. Tejasvi.
List this matter for dismissal. 31, next week.
24.
Yes.
17-4.
Huh? Why are you asking for 28 now? It's already over. Yes, 32.
32. Harini Shivanand.
No representation for dismissal.
17-4.
33 adjourned after 2 weeks.
Serial number 34 adjourned. Serial number 35. N. Krishnaswamy.
31, Your Lordship. I have insurance company appeal. We have no case now in view of Mukund Devangan's case.
31, call the 31 matter. All you people, like all these old matters, get rid of it.
Yes.
Because it's on interest part, it is difficult for the insurance company and for the claimants because all stays are there, it is difficult for them.
Yes. When the
Wherever you make out a list, no, with all these kind of things, all these
do.
pay and recover and all, give it to the court officer. Will take 1 day.
Yes.
If not Friday, I will take on someday on 3:30 or like that.
Obliged you. I'll do that. But
Yes.
I have challenged the ground on the ground of liabilities to contending that the driver was having insured vehicle was driven by a person who had a LMV tractor license, but he was found to be driving a tractor and trailer. Because in the year 2012, there was claim petition and appeal was also filed.
That Mukund Devangan will apply.
Now Mukund Devangan also, and thereafter so several judgments have come up that a person having the DL to drive LMV tractor can also drive tractor and trailer, Your Lordship,
Yes.
provided the unladen weight of both together should not exceed 7,500. So I've gone exhibit R1 and R2, we got it marked. As per that also, both tractor and trailer will not go beyond say 7,500. Therefore, we do not have any case in this case.
No, every tractor and trailer differs.
Yes, Your Lordship, but yes, because commercial tractor and trailers, their weightage will be more than that. I did that Googling also. There they say it usually commercial tractors and trailers will go even up to 15,900 kilograms.
The present appeal is filed by the insurance company, agreed with award passed in MBC number 272 of 2010, dated 26 August 2026. The tribunal has fixed the liability on the insurance company. It is a contention of the insurance land counsel for the insurance company that the driver driving the tractor and trailer is having the driving license to drive only LMB
Tractor.
LMB
LMV into bracket tractor.
LMB bracket tractor, and there is no endorsement for a non-transport to drive the non-transport
tractor and
vehicle.
trailer.
To transport the non.
Because section 10 of IMV Act, it specifically says that there is specific endorsement should be there.
There is no endorsement of the tractor trailer. In the light, it is not, the land counsel for the appellant does not dispute the fact that the vehicle, the weight of the vehicle is less than 7,500. Less than 7,500.
As per exhibit R1 and R2.
As per exhibit R1 and R2. In the light of the above, this matter squarely covered by the judgment of the Honorable Apex Court in Mukund Devangan versus so and so. In that view of the matter, nothing serves a consideration. The insurance company's appeal has to be dismissed. Accordingly, the appeal is dismissed. The amount in deposit shall be forthwith transferred.
Placed.
The remaining amount, if any, shall be deposited within 8 weeks.
Till number 35. N. Krishnaswamy. 35. N. Krishnaswamy.
My lordship, the insurer company appeal, my lordship, challenging the liability, my lordship. And my lordship, for the
There is other
respondent number
matters
1, I'm
which
filing
I
the
gave it
dispensation,
to
my
the
lordship.
1 o'clock. Matters have come. Ask the advocates because it's all, yes. Yes.
Respondent number 2, I'm filing the dispensation for the owner of the offending vehicle, my lordship. We challenge the only one ground, my lordship. There is no FC for the two-wheeler, my lordship.
No?
FC.
FC means?
Fitness certificate.
Fitness certificate.
Yes, my lordship. It was expired at the time of the occurrence of the accident. So pain recovery may be passed on this case. As per the
He has issued the policy after expiry of the
But it is your duty to look into it before granting,
correct, my lordship. As per the section 39 of the MV Act, my lordship, once the 15 years cross the any vehicle, my lordship.
But why did you insure it?
My lordship.
But why did you insure it?
Insurance is mandatory provision, my lordship, as per the section 147.
But you can't blow hot and cold, isn't it? You say the vehicle has no fitness certificate.
Correct, my lordship.
Vehicles which have crossed 15 years, there can't be any fitness certificate to that.
No, my lordship, they can make a fitness certificate is
No,
mandatory.
but it's your
provision,
duty to verify whether there is a fitness certificate before
very
granting
difficult
it.
to verify, my lordship, because very difficult to verify. Once they
No, not verify. They'll give you, if you ask for a fitness certificate, they will provide that fitness certificate, isn't it?
No, my lordship. First, they need to get the policy emission. Then they go for the RTO for the grant the fitness certificate. My lordship. This is a procedure for the RTO.
What is the judgment? Please take the judgment.
It is the duty of the insurance company to demand the owner to furnish all the relevant documents before acceptance.
Where is it?
Without insurance, my lordship, fitness certificate is
Look
not
at,
possible.
it is not a new vehicle.
No, my lordship, is not a new vehicle. It's an old.
It's an old vehicle.
Correct.
Yes. Where is it? Which paragraph? You have the judgment?
No.
No, read along with him. Look at it. The life of an insurance policy. Please read. No, where are you reading? Paragraph 9 or which paragraph? It starts with the life of an insurance policy.
The life of the insurance policy issued in respect of the motor vehicle will be valid for 1 year and for every next year. Either it has to be renewed or new policy has to be obtained. Therefore, the insurer at every time of issuing a vehicle and issuing policy, renewing such policy should verify whether the vehicle has possessed all the necessary certificates, including the fitness certificate. The insurance company cannot blindly insure motor vehicles and have a premium and thereafter contend that the vehicle is not possess fitness certificate at the current point of time and therefore they are not paid compensation. This attitude of the insurer cannot be encouraged any longer. In insurance case, as per Procedural, endorsement dated 28 was issued by the RTO at the center at the request of the insurer. The FCs of the offending vehicle has been renewed up to 21/2007. As per R2, the second result insured the offending vehicle on 5/2/2008 valid up to midnight 4/2/2009. This is the same thing happened in this case also. So at the time of issuing the vehicle itself, insuring the vehicle itself, the vehicle was not having the fitness certificate, much less as of 5/2/2008. Date on which the vehicle was insured. These things happen because the insurance companies do not employ trained agents on permanent basis fixing responsibility. The agents now working in the vehicle.
Same, the court has still that pay and recover, though the same thing is at paragraph number 11. It is upheld. The insurance
But
company.
my contention is, my lordship, section 39 will says
No,
that,
no.
my lord.
This also ultimately says pay and recover.
Yes, ma'am.
That's what he was also saying first itself.
But it comes to the OD claim, my lordship, is not a.
The counsel for the insurance companies before this court agreed with award passed in MBC number 1880 of 2015 dated 12th April 2017, whereby the tribunal has fixed a liability on the insurance company and granted compensation to the claimant. Land counsel appearing for the insurance company submits that as on the date the accident had taken place, there is no fitness certificate to the offending vehicle when there is no fitness certificate, which amounts to breach of the terms and conditions of the policy, and the insurance company is not liable to pay the compensation. Land counsel appearing for the claimant had relied on the judgment passed by a coordinate bench of this court in Sri Rangappa alias Rangappa Shetty versus Sri Jairamaya and another, reported in ILR 2014 Karnataka 191, submits that it's the responsibility of the insurance company to see whether there is a fitness certificate before issuing renewing the insurance policy. Having issued the policy, renewed the policy, it is not open for the insurance company to say that they are not liable to pay the compensation as there is no fitness certificate. In response to that, Land Counsel for the insurance company submits that in the very same judgment, having observed so, still this court has directed the insurance company to pay and recover the same from the owner of the vehicle. Having heard so and so, in the light of the admitted fact that there is no fitness certificate to the vehicle, and also even in those circumstances, the principle of pay and recover will apply. This court is of the view that the insurance company shall pay the amount and record the same from the owner of the vehicle. Then why are you seeking dispensation?
My lordship, we take the 5 times for the owner of the vehicle, my lordship.
You are seeking dispensation because you remain ex parte.
Yes,
Docket order. A memo is filed seeking dispensation or notice to the owner of the vehicle. There should be the other order. He was ex parte before the court, and even before this court also, they have tried to serve the notice for 5 times.
5 times.
And which could not be served. Hence, the appellant seeks dispensation of notice to the owner of the vehicle. Accordingly, the same is dispensed with at the risk of appellant. In the light of the above, the appeal of the insurance company is partly allowed by applying the principle of pay and recover. The insurance company shall deposit the amount within 12.
And deposit may be transferred.
And the amount in deposit shall be forthwith transferred. Yes, next.
Oblige,
Matters moved.
As per the conditions imposed. Yes.
Matters moved at 10:30. Rahul S. Reddy, publisher.
My lords, I appear for the petitioners in this matter.
When was the auction?
4-3, ma'am.
They have also taken possession of the property. Now today they have come that at least now, at least we will pay the gold to your amount of 11 lakhs. And bank says it's gold, but they have paid only 4 lakhs. Anyway, now you cannot even, they are also very considerate. Okay.
Now, how can you accept the payment after the auction is done?
Oh, they sent by RTGS.
In the light of the judgment of the Supreme Court,
Please.
there can't be any redemption of the mortgage after the auction notice is
But
issued.
what happened, my lords, after the sale also, my lords, when they came to take possession, we requested with the bank because the scheduled property is a house, residential
They
house.
can't, unless until the sale set aside after the amendment to 13(8), you have no right.
My lords,
No, somebody's, the valuable rights have accrued to the auction purchaser.
my lords, but my request is,
Now you can only question the auction on the ground of any illegality.
my lords, with respect to that illegality, I have already filed a petition before the debt recovery tribunal. That is still
And now you
pending.
are coming here.
My prayer here is very limited, my lords. Don't evict us from the property till disposal of my
Not at
case
all.
application.
First of all, you stand on a worse footing compared to the others who are coming to the court every day. Come.
My request is, my lords,
No.
it is a scheduled property, the residential house.
Whatever it is, ask the relief from the DRT.
In fact, the bank agreed to regularize the
We
account.
cannot do it. We can't do it. The
But they
expedition is
even
fine.
took a payment from us, my lords.
Huh?
Yesterday, they took a payment from us.
If that is between you and that both of you have to settle.
In fact,
If they're accepting.
they told my lords, if a payment of 10.5 lakh is made yesterday itself, it would be regularized.
If they take the payment, if any writ petition comes to this court, will initiate appropriate, will ask the Reserve Bank of India to initiate proceedings against this man.
My lords,
Or don't it?
I have a receipt for making the payment also, my lords.
If they're accepting, that's not, that is there, you please got it, take it to the DRT.
Even now, my lords, if the bank agrees that we are ready to make the outstanding amount.
Please understand, legally, this court cannot do those kind of things.
I understand, my lords, by
It's a legal aspect, not like, you just can't, it's not something that the court is giving court has its own restrictions, isn't it? Because it is exercising the jurisdiction under 226, that doesn't mean that the court can do anything. Court is bound by the settled law and the legal principles. And this is the whole difficulty in entertaining these kind of petitions and asking you to pay the amount. Then the auction purchaser will come. In some cases, they will take the money both from auction purchaser and from the borrower. We can't create that kind of a litigation. Please come. The present writ petition is filed seeking the following prayer. Land counsel for the petitioner submits that the petitioner is ready to pay the amount. In fact, he has already paid an amount of rupees
4 lakhs
yesterday. 4 lakhs yesterday.
And
bank is insisting for 10 lakhs.
Insisted for 10 lakhs.
Insisting for 10 lakhs. Land counsel appearing
11 lakhs.
Insisting for 11 lakhs. Land counsel appearing for the respondent bank submits that the auction was conducted and the auction purchaser has paid 20% of the amount, 25% of the amount. It is also submitted that the questioning the auction proceedings, the petitioner has already approached the DRT by filing
SA 159 of 2026.
SA number 159 of 2026. It is submitted that at this point of time, once the auction purchaser has already paid 20% of the amount, 25% of the amount. Now the bank cannot regularize the account. Bank cannot regularize the account. Now the land counsel submits that they are ready to pay the amount. Now, having heard so and so, the land counsel submits that is ready to pay the amount. Once, in view of the amendment to section 13(8) of the Surface Act, once the auction notice is issued, the borrower will lose its right of redemption. According to the petitioner, the bank is ready to take the amount. If it is ready to take the amount, if it is, that is between the bank and the petitioner, and this court cannot pass any order, as the same is contrary to section 13(8) of the Surface Act. Further, the petitioner has already initiated the proceedings before the DRT. As having initiated the proceedings before the DRT, he can take it further. Any other relief he can seek before the DRT, but not before this court. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT, and he shall have one day. He shall have
what would happen is the findings in this honorable court, my lords, would affect me in the DRT proceedings also.
Because it is not a finding, it is law.
I understand, my lords.
Any of the findings in this,
or I may be permitted to withdraw itself, my lords.
This court has not expressed any view on the merits of the matter, and any of the expressions in this order shall not be construed. Any observations of this court in the above order shall not be construed as an expression of this court.
Now,
and the DRT shall decide the same independently.
Now, what has happened? Yesterday, I made a payment of 4 lakh. Now, my lords, I just got an information like 20-25 minutes back, another 4 lakh has been transferred. So 8 lakhs have been transferred from my.
Already 2.5 lakhs is there in the.
And another aspect is, my lords, 2.5 lakh was in my account. So that has been blocked by the bank.
All this, you will get it right only before the auction notice. Now, at this point of time, even when they are asking, you shouldn't go forward with that.
Now, what my
bring it to the notice of the DRT. What has been done?
What happened? The confusion caused is, my lords. When the bank officials came near the house, it was upon their intimation only we will make the overdue amount payment. At least leave the because it's a residential house. We are in the
So you show one communication from the bank saying that you pay the amount, then I'll interfere.
oral communication.
Yes, next.
Now whereas I made a payment also, now I don't have my house also.
Yes.
Serial number 2, 14%.
Please, madam.
Oh, and for the bank, Mr. T.P. Muttanna, for the respondent. Uh-huh. You're referring to this case or the earlier? Let me see what it is.
Oh, sorry, sir.
What is this? No, first case. Let me look at it. You are not appearing.
Not appearing in this case. And there I handed over to the person on Ashok Naik, who appeared in his earlier representation, the same matter, and they will give the case to him. Now Ashok Naik, I think, is appearing on behalf of the bank.
Where is he?
No, because his one call is mentioned.
No. You please call. No, understand. Please call your bank. Please call your bank and tell them. No, tell them either somebody has to represent before the court or else I'll consider and grant interim order.
My lord, he accepted the note.
I'll hear you. Please wait. Please use the mic.
I think that all those things accumulated into 10 lakhs. And now last year I think 25. He came and after 10 years ago, all this you pay 5.2 lakhs, you do the money. And he has not paid 5.2 lakhs. And then I was what they said. Full details I do not know because they are not given interest to me. And that Ashok Naik will come and ask.
Yes, please come to your. What is the prayer you are seeking before this court?
I am seeking a quashing of these two, one demand notice as per exhibit.
So what the procedure is, when a 13-2 demand notice is given to you, you shouldn't come to the court. When a 13-2 demand notice is given to you, you should reply to that.
It is a provision is there.
No provision will allow you to come here.
It is not a compulsory that
It is compulsory. You can't come to the High Court. High Court will not, before 13-2 and then further steps, court will not interfere with all that. You have to issue a reply to them, and even after the reply or any steps that are taken by the bank, if you are agreed by it, you should go to the DRT, but not to this court.
My lord, this respondent bank has acted against the provisions of the statutory provisions and in violation of the Reserve Bank of India guidelines.
Give a reply to them. Give a reply to them on 13.3A.
Because this honorable court has given liberty to me to challenge this order. Any order is initiated.
Any order means not here, not before this court. To give liberty is liberty to go before the DRT, not before this court. And first of all, they have given a notice under 13.2. Please give a reply to that.
My lord, my humble submission is that I am a senior citizen. I am sufficiently aged. I fought a earlier writ petition litigation on the hopes that it will come to an end. As per in compliance with the order of this honorable court, I produced a demand draft of 5,50,000 rupees. And
there are only one is you have to go to the DRT. Otherwise, you want an order from this court.
Yes.
No interim order will be granted.
My lord, I am ready
to. The respondent will come and file their objection.
My lord, I am ready to pay the amount whatever they are demanded.
We have to understand. They have to file their objections. Then only we can understand. At this stage, we can't do anything. If you want, I can order notice and I'll ask them to file their objections within 2 weeks. Then we can decide. Or else I have to send you to the DRT. because you're a senior citizen, looking at that fact, I'll ask them to file the objections. Once they file the objections, I look into that and pass orders.
A week's time may be given. To
How
file the
much?
objection.
How much time should be
A
given?
week's time.
The present petition is filed.
By
Questioning
1/4 I will file.
Questioning the 13-2 notice issued by the bank. Generally, in a normal course, when a 13-2 notice is issued, the party has to reply to the same as contemplated under section 13(3)(a). Considering the fact that the petitioner, what is your age?
My age is 76. I have completed.
Petitioner
About to
is
complete
aged about
77 years.
76 years. And considering the different contentions raised, this court, in the facts and circumstances of this case, deems it appropriate to direct the bank to file its objections within a week. This is matter on.
No, on first day it can be registered. On first.
Not possible.
For that I will file.
Not possible. List this matter on 8th of April.
8.
No, whose name it is? Print the name of Mr. and inform him also. Tell the bank, Ashok Naik, print the name of Mr. Ashok Naik is directed to take notice on behalf of the respondent bank. Delete the name of Mr. Muttana. And where are the, take that, no, that second list is there. If party, educate sir.
List number 2, serial number 1. List number 2, serial number 174.
Yes.
Serial number 2, Kalimullah Sharif.
Yes. Next.
Serial number 3. That is also 17.
Yes, 4.
Serial number 4. That is he requested on after petition.
Oh, interim order is there. List this matter on 7th. No, that's true. Today, because I thought I'll not be able to reach these matters, so all I have adjourned. So this matter on 7th. Maybe he might have asked, but make it 7th and inform it. Is 5.
Serial number 5.
Commissioner.
Yes.
Last occasion, my lord, there is a challenge, my lord. 72,000 is a overdue amount. Out of it, 68,000 rupees has paid, my lord. 19.
What is outstanding amount? That's what I'm asking. 39,000. But what you say 70?
EMI, my lord. Overdue amount, they issued a demand notice for overdue amount account.
You are not ready to regularize amount account?
Subject to payment of the expenses incurred.
What would be the amount?
The expenses and overdue amount will come up to 25,000 plus 1 lakh.
30?
25,000 plus 1,35,000 is the amount for regularization.
And you don't argue on how that amount has come.
No.
If you argue, I will not entertain.
I am not arguing on that.
1 lakh, according to them, to regularize the account, you need to pay 1,35,000.
68,000.
You have already paid?
68,000 rupees.
So what is the remaining? Huh? Apart from?
This is apart from 68,000 which they have paid.
Oh, apart from that is 1,35,000.
Yes. How could that, my lord? Only 72,000.
Well, how it could be that we will not answer to that? If you're ready, I can pass an order. If the petitioner pays the entire, whatever is the outstanding amount as per
one
the
submission,
bank, the
my
amount
lord.
will be
They are
regularized.
not only one submission. My submission is, my lord, I will pay the amount. Expenses, I am ready to. Last occasion, I submitted that I will pay that amount, my lord. They said 95,000, out of it 65, only 27,000 balance. Now they saying 1 lakh, apart from 78 to 72,000.
That's not for this court to calculate, Mr. Counsel.
My lord, one submission, my lord. I am ready to pay, my lord. Some time has to be given, my lord. Otherwise, my lord, he is a vegetable vendor, my lord. He was a hospital.
Pay when you will pay.
8 weeks made me,
Huh?
8 weeks time, ma'am. 8 weeks. Yesterday, my lord, last week, 68,000 rupees I paid. Some concession is shown, my lord. He's an age-old man. He was hospitalized. His eye bleeding.
Come up with an undertaking affidavit, 4 weeks we will grant. Then we'll dispose it of. List this matter on first. By the time land comes for the petitioner shall, not land comes, the petitioner shall file an undertaking before this court that he will pay an amount of rupees 1,35,000.
Please.
35,000 within 4 weeks. Yes, list this matter on. We want on first or second?
Second, Your Lordship.
Second.
First is a matter.
Second. Yes, next.
In a matter.
Number 6.
Yes.
Till then, my lord, not to direct the
Till
response,
such,
not,
till second, not to take any coercive step.
please.
Any signature?
Ma'am, serial number 6. Ma'am, serial number 6.
117.
Serial number 6.
Serial number 664, date 2004. List number 201 RP 17.4, that MFML is there. And 2 is 16.4. 3 is also 16.4. 4 to 7.4. And 5th is 2.4.
16 or 17?
16.4. 17 MFA. First one is MFA, that is RP and MFA. And 6 is on 6.
Madam, 31, serial number 31 ಯಾವಾಗ madam?
31 ಯಾವ ಲಿಸ್ಟ್ ಸರ್?
First list madam.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ 31 ಒಂದು ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 38 MFA ಅದು ಅದೇನ್ ಆಗೋಯ್ತು ನೀವು ಇಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಕೊಟ್ಟೋಯ್ತಲ್ಲ
ಮಂಡೆಗಿತ್ತು ಯಾವ ಡೇಟ್ ಹೋಯ್ತು ಈ ರಿಟ್ ಪಿಟಿಷನ್
ಎಷ್ಟು ಹೇಳಿ ಮೇಡಮ್ 34 17 4 ಗೆ 17 4
ಹೌದು ಮಂಡೇ ಇತ್ತು
ಓಕೆ 28
31 madam.
started on 24 4 31 ಒಂದು ನಿಮಿಷ ಸರ್ 31 ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಸರ್ ಅದು
ಏನಾಯ್ತು ಮೇಡಮ್?
ಡಿಸ್ಮಿಸ್ಡ್ ಅದು
ಸರಿ ಮೇಡಮ್ ಓಕೆ. ಸರಿ ಮೇಡಮ್ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು.